Okay, ladies and gentlemen, gentlemen and ladies, ladies and gents, I want you all to understand that I got something on my mind and I want to share it with y'all. I've been finding it out lately. We're going to play Michael Jackson singing to his wonderful president, Clinton, after he was elected in 1993, dedicating this song to Ryan White. Ladies and gentlemen, I have been finding it as of late, and I have a difficult time with it. And I need to say this to all of you because a lot of people are not getting it. They're not understanding. The truth is, I don't think like you. I don't see things the way you see it. That isn't because I'm different and you're different. That is because my thought processes are different. The way I formulate ideas, formulate angles at looking at things. People have not been taught how to think outside the box. You hear people talk about it all the time. You got to think outside the box. And they think they understand what that means, but they don't. They think thinking outside the box means coming up with another idea that's not within that arena. Well, actually, that's exactly what it means, but that's not what they think it means when they are thinking about it. See, they can explain it, but they don't actually do it. So, can I give you guys an example? Gone too soon, y'all. We're gonna go over this now. I want you guys to see how I'm creating this document. This is gonna be the motion to compel for criminal matters or those cases where you've been charged with something, including a traffic ticket, by the way. Okay, want you to pay attention. This is for California, so as I told you, you'll highlight California simply by this. Let's copy and we'll do replace. And then we go here. Okay, and what we're going to do every time we see California, but you're going to do your state. See how I put California here? You see how I put California here? You're going to do your state. I don't want to do that. Got to get rid of that. Whew. Get rid of that. Gone too soon. Okay, now this is what I want to do for California. Now remember, some of the cases are California cases, so what I have to do is I have to go slow. Let's do that right there. Do that there, 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 do that there. Can't do that one. See, that's what I mean. That's actually part of the code. Oh no, I can do that. Sorry, I can do that. That's part of the code, but you have to change the code. What I can't do is these right here that say California. Watch, replace. And we can replace that, but we can't replace that, so we have to go to the next one. That's why this is so important, because you'll have to replace it with your state civil code. So you'll have to find your state code. So you take the section and you replace it with your state information. It is real simple. You just take the section, put it in Google. See right here, I can't change that because that's the actual case name. Okay, so that's why I have to be careful in what I'm doing because of the cases that are named. This is Anita Baker, ladies and gentlemen. Now this one says California, so I can't change that because that's the actual case information. But I can't and don't have to change that. Okay, because that is the Supreme Court of California. And then I do that. Now remember, those of you who don't know much about arbitration, remember the rules of arbitration are uniform. That means every state's arbitration act has to be in line with has to be in agreement with the Arbitration Act known as the FAA, Federal Arbitration Act. Now, ladies and gentlemen, I could not have explained arbitration to you a month ago. I could not have done it 3 months ago. I can only give you bits and pieces of it. But as you see, this is all I've been going over to make sure I know what I'm talking about, and then going over the case law to make sure I know what I'm talking about. Going over the latest case law, and then going over the basic understanding. You go over the Arbitration Act itself, you'll find that it is a private remedy. It is a common law remedy. What they did is they made a statutory provision for it so that they could control it. The only problem is they don't have enough control. Let me explain why. Hey, Anita, hold on 1 second, okay? The respondents admitted that they have acted in conspiracy to deprive the presenter of his or her rights. So what you're going to do is put her if you're not a his, okay? If you one of them people who want to do the gender thing, it's not necessary in this document. Sorry about that. It's a different subject, ladies and gentlemen. So don't add to it. See, that's why I'm doing this video. I was having a conversation with someone yesterday, and we were going over some minor details, and I explained to him, no, you have to mention this and you have to mention that. And the person said, well, I don't see why I have to do that. And I had to basically tell him it's not necessary for you to see. I didn't tell him like that, but that's was the frustration I was feeling inside of me. Nobody said that you had to agree with reality. Nobody said that you had to agree with the process. This is the way it is. So just get in line. Ladies and gentlemen, this is the process. Quit trying to add to it. I had one person tell me, well, did you mention this and did you mention that in your contract? And did you add this and you add that? At least 9 people have communicated with me who I allow to communicate with me about whether or not I added certain things into the contract. Ladies and gentlemen, I've been doing this for too long. Okay? You didn't help me put it together, so don't sit up here and ask me did I add, especially if you haven't read it. I apologize because that's what I'm going through. That's my frustration because I can't see things from other people's angles because I can't see why somebody would ask me did I put something in and they didn't read it in the first place. Especially how people know how much I hate repeating myself. And they're asking me to do exactly that. Or they're speaking to me as if I'm one of their friends whom have no knowledge of anything, no clue. And that's irritating. I'm going to continue reading now. The respondents have entered into a contract with the presenter whereby they have agreed to certain conditions and clauses and terms in that they claim, in that the claim charges for an act of interstate commerce. In that the claimed charges for an act of interstate commerce infraction, and whether or not on a state level, section 1 of FAA must be applied. Okay. In that the claim charges for an act of interstate commerce infraction is specific in nature and application, and whether on a state or federal level, section 1 of the FAA must be applied. So we're letting them know that the FAA is applicable, and that's what the courts have suggested, is that we highlight the FAA. And that's why we put section 3 and 4 here, as well as, let's they especially want us to do 3 or 4. Let's do this. 2, comma, 3, 4. No, we'll do it this way. Forget that. We'll do the whole act instead of just part of it. Okay? We'll include the whole act so that nobody can say, because this is 1 through 16. So we'll include the whole act. That way nobody can say, well, y'all didn't, and you didn't, and you should have. And okay, we don't want to hear it. All right, let's continue. The respondents can be charged with waiver and estoppel. Let's not say can be. Yeah, let's do are. The respondents are charged with waiver and estoppel as a matter of law and have no defense to the presenter. And or he is CLAIM. Now we're going to do that again. You know what? Let's do that. We're going to do copy. Then we're going to go replace, 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 replace. And we're going to go V. Okay. And we want whole words only. And we can, this one we can do that. There are 4. So that one we can do that. There are 5. Okay. All right. The law leaves the wrongdoer where it finds him. See section 50 and 51 and 52 of the American Jurisprudence, second edition, actions on page 584. No actions will lie to recover on a claim based upon or in any manner depending upon a fraudulent, illegal, or immoral transaction or contract to which the respondents were a party. Let's continue. The respondent's acts of a charge claim were against an individual for violation. Wait. Yeah, I know, that's 2 A's. Two birds, one stone, 1,000 stones, 20 billion stones. Come on now. I ain't got time. Do we want to do that one? Yeah, we'll do that one. The respondent's allegations of a charge or charges that they claim were against an individual for violation of federal law and or state law whereby interstate and or foreign commerce is alleged to have been trespassed upon and I need something. We're going to do 1. The reason why we're putting the 9 USC 1 here and saying that it is a matter that is to be applied to that is because, again, the issue is the court has no jurisdiction, and that's what we are taking away from them. Now, we keep repeating that it must be applied. This is what I'm looking for. Copy. Tick tock, tick tock, tick tock. Okay. That's me yawning. The presenter made no misinformation to the respondents who chose to ignore each of the requests for validation of the obligation, or excuse me, the origination of the charge, where did the charge originate from? Did it originate from law? Of course it didn't. It originated from statute. And it needed your consent, which is why they bring you in there under force, duress, and coercion, so that you would sit up there and plead. It's okay, we've taken care of that. The respondents admitted that all crimes or any of the following types of crimes, federal or state, are commercial crimes, and we take that section. Now you notice, pay attention, we did not mention 27 CFR 7211. You don't see 27 CFR anywhere around here, because all we're pointing out is that they've already admitted to these facts that are here. You got me? You feel me? I know you do. Says the respondents were notified as to the claim of dispute between the presenter, dispute by the presenter, and that there was a charge of breach of the agreement, and at every instance they refused to provide a complete comprehensive accounting certified by a licensed accountant as required by law. Ladies and gentlemen, this is a commercial transaction. We want an accounting. It's a commercial transaction. The courts operate under commerce. They're administrative. You don't have to say this in court. It's not necessary. They've already agreed to it in a contract. Whew. All right, let me finish. Contracts dealing with consumer transactions. This matter involves a commercial transaction, placing it within the jurisdiction of the United States Congress, who has the premier right of regulating commerce and incorporates the Federal Arbitration Act, FAA 9, 1 through, and let's do, you see where it says FAA 9, 1 through C? Let's do this. Okay, let's do that. That way we have the, and nobody can say, oh, we don't understand what that means. And then this is where we do the commercial crimes. Now, but you'll say, but you already put that there. You're absolutely right. Oh, I'm sorry. No, we don't need to have this here. Sorry, it's there again. So that was there before. I added in the other section this morning. I haven't made the document yet. I'm bringing this so that I could show you what we're doing, how we've added everything. Now, as we explained in video yesterday, ladies and gentlemen, because all crimes are commercial, and as you saw by the wording of that, all crimes are commercial. When you go and you reread it, none of those crimes are murder or assault and battery. None of those are what do you call common law crimes, where you've injured another party, where there's a corpus delicti. Those are those crimes. Everybody where's the corpus delicti? No, those are those commercial crimes where there doesn't have to be a corpus delicti. Corpus delicti? What's that? An actual party, an injured party. Corpus meaning body, delicti meaning party. I mean, not party, injured. So nobody received sustained injury. Shortly after the presenter became aware of the fraud committed against, and we're going to put him or her. Where's my mouse? There you go. So we're going to put his yeah, let's do this. Easy. We'll do his person and interest, and we'll highlight the his again so that what person it means. No, we're not doing that. They've already agreed. Okay, the contract already highlights that. We don't have to play with words here, people. The contract has already been agreed to. So please stop all of that ignorance. I told you it's already been covered. Shortly after the presenter became aware of the fraud committed against his person and interest, referencing a commercial contract, The respondents made several attempts to change the terms and conditions of the original binding contract. Upon the last attempt to change or alter the terms and conditions of the contract, the plaintiff presented, and let's not do plaintiff, we were supposed to change that. We're going to put presenter. Presented a conditional acceptance of offer / counter offer, whereby the respondents, if they did not agree, had opportunity to express such disagreement while complying with the duty to respond. Based on the previous relationship, responsibilities, obligations then in existence between the parties, and it's supposed to be their intentional, deliberate, and willful. So we'll do their intentional, deliberate. So let's make sure that it says and. Okay. And they're intentional, deliberate, knowing, willful. Any act must be intentional, it must be knowing, and it must be willful. In other words, the person, and it's supposed to be made the, come on, getting on my nerves. They're intentional, deliberate, and willful. Nah, we can get rid of this right here. They, comma, the respondents, we ain't getting rid of you, okay, made the conscious choice to acquiesce by not challenging the new contract in any of its aspects, creating tacit acquiescence and estoppel respecting the respondents. Um, uh-oh, can't have two R's, can only have one R. Okay, now, although not mentioned in the complaint, the commercial agreement also contains an all-encompassing binding and enforceable arbitration clause, at which provides in pertinent part the following. We don't need to go over the arbitration clause because, pay attention, the respondents have agreed that any and all challenges, disputes, and other related matters were to be addressed by arbitration. Thus, they have waived any and all rights and are estopped from bringing forth any challenges in the present matter. Note the agreement clause respecting arbitration sesmerized, it was sesmerized, Your Honor, summarized here in part and incorporated herein by reference. So we put part of it here, but we incorporate the entire arbitration clause and arbitration reference here by reference. As a matter of fact, I gotta highlight this because this is what y'all need to understand. Y'all need to understand y'all gotta create your own's number. Where's my highlighter? There you go, highlight. It's a Miller time, y'all. Miller highlight. Okay, we can skip past this. Now, I want y'all to pay attention because, like I said, we added some things. So watch this. The undersigned respectfully requests this court compel arbitration per the agreement through the amended arbitration association. So it's not the under the commercial arbitration rules now in effect. That such is appropriate. Okay, we don't want that right there. The arbitration association under its commercial arbitration rules now in effect. We can get rid of the now in effect. This was for the other document. So that such is appropriate as California or whatever state you're in has established a policy of favoring arbitration. The parties entered into a valid arbitration agreement, and the arbitration clause contained in the commercial agreement is clear and unambiguous. Moreover, none of the parties have waived the opportunity to arbitrate, as the respondents have voluntarily granted power of attorney and authority respecting such to the presenter in this instant matter. As such, the court, in line with statute, must compel arbitration. The contract specifies on or about pages 4 through 7, one more, in part that there was a continuing and running challenge to jurisdiction. If you did the one for incarceration, there is a section that says continuing and running challenge to jurisdiction. Yes, we're challenging their jurisdiction, and they recognized it. That the most novice of the legally wise are aware that they have the right to challenge jurisdiction, that they can challenge jurisdiction at any time, and that jurisdiction, once challenged, must be proved. Now, this is where we got to get rid of that right there. I knew it was there. Where's my mouse? I got to change my mouse, y'all, again, because I can't see my mouse on this white page. So what we're going to do is we get rid of that, and we make it universal. Acting on behalf of the alleged defendant did not enter anybody's plea, do not permit anyone to enter a plea, shall never enter a plea. I have not, do not, and shall not be forced and or compelled to enter your jurisdiction and or a plea. But I did do it. It doesn't matter. You're not paying attention. That the issue of a trial or hearing exists when the plaintiff or defendant arrives at some specific or matter in which one affirms and the other denies. A court does not create the issue by asking the name of the defendant, how he disputes to the charges. That if there is a statute or a law within and upon the face of a charging document instrument which alleges charges a violation of an unconstitutional statute or law, or is from another state or legal entity, or even an non-constitutional legislative entity, such as those statutes, laws cited in the United States Code, specifically blah, 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 thereof within and upon the face of the warrant of arrest, charging document, instrument, indictment, and affidavit. Wait, we need to do one more. But this is taken from that. Yeah, we're going to leave it that way. But remember, let's make sure it's there. Yeah, they didn't put information, but they said charging document. So in some states, they do it based on information. Guess what? The information is taken care of by charging document. An affidavit in support thereof within the above reference alleged criminal case cause a defendant, and specifically the named defendant within the above reference alleged criminal case cause, in the act of entering a plea or the verdict thereto or therein, does not thereby or therein admit to the genesis of said charge, document, instrument, indictment, and does not admit to the validity of the statute or law cited therein, and does not thereby form the issue for a trial, which would exist even without a plea and without there would be anything before the court or jury for trial. Guess what, ladies and gentlemen? All we did was took what was in the case and we did this. Pay attention. Which states the very act of pleading to it an indictment admits its genesis as a record. This is what they did. When you enter a plea, they get jurisdiction, which states the plea forms the issue to be tried, without which there is nothing before the court or jury for trial. That the right to not enter a plea, entering a plea is the first step in granting the court jurisdiction to hear a matter. It is elementary rule of pleading that a plea to the jurisdiction is the first step in the order of pleading, and that any other additional plea which refers to the court any additional proof and or acknowledgement of the question is a tacit admission, tacit acquiescence, that the court has the right or jurisdiction to judge in the cause, i.e. subject matter jurisdiction, and is a waiver of all exceptions, i.e. acquiescence, whereby no challenges can be allowed respecting the jurisdiction. Okay, ladies and gentlemen, guess what I did? In this current matter, they were threatening. And so I basically told them, I guess we'll have to be not guilty. You guess. Yeah, I was guessing. I'm sorry, but I was guessing. Why? Because that was the thing to do. Why? Because if you've ever played baseball, if you've ever watched baseball, and I know a lot of you guys are them American people, so y'all watch a lot of baseball, you'll know that there are three people who you pay attention to in a baseball game: the batter, the pitcher, and the catcher. Why don't you pay attention to nobody else? Because without those three, nothing else goes on that field. If there's no batter, there's no game. If there's no pitcher, there's no game. If there's no catcher, there's no game. But I played baseball without a catcher before, and we just had to get our own ball. That's right. So you go right ahead and keep going and getting your own ball and going and play on out there by yourself. Okay? We gonna focus on the reality. Ladies and gentlemen, without the guessing work, I need to set them up. What a pitcher does, he sets up a batter. He'll throw a couple of pitches to see where the batter is swinging, and then he'll set him up for that strike and set him up for that third strike. Whereas the batter will sit up there and fake the pitcher out by pretending to miss, pretending to swing and strike, only to get the pitcher to throw the pitch he wants. Now, the catcher is watching the batter, and he can tell by certain movements of the batter and his stance what he's getting ready to do, whether or not he's getting ready to knock that sucker clear up into Jupiter's orbit. And so everybody's trying to set everybody else up. Ladies and gentlemen, my job is to set people up. When I walk into that arena, I'm not walking into that arena giving them jurisdiction. I'm walking into that arena taking their jurisdiction and adding some, why, let's just say I'm giving it right back to them the way they deserve it. Let's continue. That whenever it appears on a record that the court has no jurisdiction, i.e. want of jurisdiction, nothing which the parties may do or admit to do will give it. That is, jurisdiction to the court. But where want of jurisdiction may exist, consistently with the record, fingerprints, presumption, assumptions, photograph, affidavits, documents, statements, a plea to the action, either entered by the court or by counsel or attorney or by a party is a waiver of any exception to the jurisdiction, i.e., the party waives his right and is subject to the jurisdiction of the court. It is so nice that your contracts specifically state that you cannot waive that right, that your contracts are irrevocable, binding, and self executing. Ladies and gentlemen, do your research on what an irrevocable contract is. Okay? That within and upon the face of the record of the court of record, in the above referenced alleged criminal case cause, the nature and statute of laws cited within or upon the face of the warrant of arrest, charging document, instrument, indictment, the affidavits in support thereof, as relied upon by said court to assume its jurisdiction in the case cause, and over and upon the parties therein, and the consequences of entering a plea, as established supra at proof of claim, were disclosed to the above named defendant, wherein the above reference alleged charged criminal case cause and the undersigned by any officer of said court and or the United States, and was not rather actively concealed and hidden from the named defendant to the undersigned by said officers, and such concealment does not operate to constitute and establish acts of fraud upon and against the named defendant and the undersigned, wherein the above referenced alleged criminal cause case, that the proceedings in which the named defendant and the undersigned were subject within the above referenced alleged criminal case cause were not in equity chancery, and the conflict was not with the non-constitutional source of authority for the existence of statute law alleged charged as violations within and upon the face of the warrant of arrest, charging document, instrument, and yes, I know it says violated anyway, and affidavits in support thereof. That the court and the legal system today, specifically the alleged court of record within the above reference alleged criminal case cause, can and do recognize and proceed upon common law crimes offenses, and therefore acts which are above which are made crimes offenses and not made by statute, rather code. Commercial law and common law are not the same. They don't act with each other. Common law is not made by statute nor by code, but the courts do recognize and proceed upon common law all the time. See, common law crimes and offenses. Mr. Bradley Stark recognized this without me having to point that out to him. I am so happy about that. Let's go on. You'll get it. Just go back over what I said and read over what he just wrote. Now, the rest of this document is the rest of this document. Okay? But we put here, pay attention, that all crimes are commercial. Everything we just said here, the parties have agreed to in contract. They've agreed to all of this. Not only did we put all crimes are commercial, but he put the United States versus Volungas, 2010, United States versus Pearson, Fifth Circuit, and that was 1998. We've known all crimes are commercial. So the only way to get them with the all crimes are commercial and hit them right smack dead dab there in their face is to formulate the contract and get their attention. Ladies and gentlemen, that's what we're doing. We're getting their attention. That's what we're doing. That's why I say the document, you don't have to add anything else. We focus on the main things. Don't bring up all of those other points that you think need to be brought up. It's not necessary. It's already in the contract. This document is just a motion to compel. The only thing we're saying here is that the parties have already agreed to all of the terms and conditions in that document. So you don't have to do nothing. So don't do nothing. Don't do it. You know, Beretta, okay? Keep your eye on the sparrow. Just don't do it. All right. I want to get back to my Anita Baker because that's my girl. Oh, I got to turn on my welcome to All-Tech Lansing. That's my All-Tech Lansing Bluetooth speaker. And this is my girl. Uh-oh. Well, she's on my phone. She's supposed to be on Bluetooth, but I gotta go now, y'all. Somebody's calling. But I hope this information was beneficial. Goodbye.